Hold up. Affidavit of trial counsel Mike Howard. Wait a minute. What the hell going on? Let me read this real quick to y'all. So I ain't know what. Look, Mike Howard. Just so happened. I'm working on the railroad. That's how I work. Before me, the underdesigned notary public on this day personally appeared Mike Howard, who being by me duly sworn, deposed and stated as followed. I, Mike Howard, am at least 18 years of age, of sound mind, and I am competent and qualified to make this affidavit and have personal knowledge of the facts that stated herein, that they are true and correct. I declare that I was the trial counsel supported by second chair co-counsel Toby Shook, third chair co-counsel Tasha Gupta, and briefing appellate co-counsel Michael Mauler, who represented Karmelo Anthony in the cause number of, going to the cause number, leading up to the June 1st, 2026 trial of this case. And the defense and prosecution reached an agreement where the prosecution and defense jointly agreed to not raise any alleged character, reputation, or extraneous offenses, bad acts, evidences relating to Mr. Anthony, as well as Austin Metcalf and Hunter Metcalf during the trial, hereinafter referred to as the agreement. Bruh, you my homie, but you agreeing with the ops. Yo, bruh, if I was King Vaughn and you was doing that, Courtroom, when Jesus comes. Are you on 64th Street talking to the ops talking about you making agreements, homie? You're not doing that because you know Vaughn didn't care. He had beef forever. How you doing that, bruh? That's nasty work. Agreements. I've been telling you in this video that they've been making agreements, but now we see specifically. Nah, I'm glad I went to put page to exhibit 10. Nah, bro. I'm gonna read over these exhibits later on today and get y'all through the fluff. And we reading them saying the same shit about a bunch of shit. To hell with that. Let's get to the fucking the potatoes. I ain't gonna say the other thing because that's pause. But the potatoes. Look, the lead prosecutor in this case, Bill Werski, brought up the possibilities of the agreement a number of times well before the agreement was discussed in detail and eventually reached. When mentioning a proposed agreement, Mr. Werski proposed that we try the case clean. This was the weird thing that I read before, which he defined as based only on what happened under the tent that day. So what if those twins didn't like Karmelo from the beginning, had some bias towards him from the beginning, because we seen Eddie and him in the defense's photos. He was sitting next to him at a track meet, and Eddie played for their team. So what's the chances that they could have seen Karmelo too and known who he was too? He was playing on the football team, seemed like he was pretty good. He was playing, he was running on the track team, seemed like he was really fast and he was good at that. So what's to say that they didn't know him? They can even go into it. Your defense is making agreements already, bro. No, we don't want no agreements. Bring up his past and bring up your past. Let's go. Let's go. Because I guarantee you that them boys' past is more speckled than his past. Okay, cool. Nasty. Under the tent that day, under the Memorial High School tent in the stadium on April 2nd, 2025. And not to go into character, reputation, or extraneous offense and or bad act evidence applicable to either Austin and Hunter Metcalf or Karmelo Anthony. On May 5th, 2026, Mr. Shook and Mr. Werski discussed this proposed agreement. I'm about to do my Stevie Wonder routine in one moment. Just wait. Agreement by phone. During that phone call, Mr. Shook and Mr. Werski discussed the evidence of character, reputation, and extraneous offense and bad conduct as it applied to both the Metcalf twins and Karmelo Anthony. Mr. Werski reiterated that he would be happy to try this without getting into character at all. Just on what happened today in the track meet. What is we doing? Yo, bruh. Nah. Who with me, bro? Who with me on this railroad, bro? Who's with me? Bro, your defense making agreements with these people for what, bro? These people ain't your friends, homie. You from 63rd, they from 64th. You heard Vaughn. What's wrong with you, bro? We ain't friends, bro. We used to be friends when we was kids, but we ain't friends no more, bro. What happened to that? Nasty work. On May 8, 2026, the defense and the prosecution teams met in the Collin County grand jury room, and the prosecution team gave us a document entitled State's Notice of Intent to Use Extraneous Offenses. Hereinafter, the state's notice, and we gave to them a document entitled Anthony's Motion in Limine. That's this word, limine. Okay. That's when they don't want you to say certain things in front of the jury. So they'll strike things, or they'll make a motion to say, oh, listen, man, I don't want the defense or whoever to say something that can contaminate the jury. So that's called limine, right? Boom. Regarding the admissibility of pertinent character trait evidence under the ambiguous aggressor rule. We got to go into that, bro. We got to go into that now. We got to break into that. What's that? What's the ambiguous aggressor rule? What's that? Scared of that. Scared of that. We getting on that Matlock shit now. Scared of that. I'm not playing none of these niggas. In plain English, y'all. Listen to me, y'all. You know, we're going to break this thing down for you. I'm going to get you on your shots. Look, if evidence doesn't clearly show who the initial aggressor was, the jury may be instructed to consider that uncertainty when deciding whether the defendant acted lawfully in self-defense. Let's read that again, bro. If the evidence doesn't clearly show who the initial aggressor was, the jury may be instructed to consider that uncertainty when deciding whether the defendant acted in a lawful self-defense. It's not a standalone rule that automatically favors either side. Instead, it recognizes that when the identity of the first aggressor is genuinely in dispute, that the jury must evaluate all the evidence before deciding whether the self-defense applies. So a simple way for us to break it down is the ambiguous aggressor rule comes into play when the evidence doesn't clearly show who started the confrontation. So if the jury can't determine who was the first aggressor, which we know who the hell it was, the hell y'all blind? Don't let me go back into my Stevie routine. They have to carefully consider all the evidence in deciding whether the defendant was legally justified in using force. My Sherry Amore. My glasses out, man. My Sherry Amore. Stevie could see that railroad more and more. Jesus Christ. The evidence under text code, they break down the code. Hereinafter, the defense notice. After the tendering to each other our respective extraneous filings, briefings, we then discuss the proposed agreement, which Mr. Worski referred to as a gentleman's agreement. Gentleman's agreement? What do you think we doing here? Sipping tea? How many lumps you want, sir? Mr. Worski outlined the proposed agreement as follows. Both sides tried this case without character, reputation, or extraneous evidence for either the Metcalf twins or Karmelo Anthony. Who is this guy, Mr. Worski? Who's Mr. Maybe, yo, hold up, y'all. I have to do this. Who's him? Who is Mr. How you spell his name? Because he sounds like a straight op. Word ski. Man was a Viking in his past. Worski. Hold up. And Karmelo. Hold up, son. We gotta do this, bruh. We gotta do this so we break this down the right way. Who is he? Look at who's coming up with this deal. I already thought I knew who he was, but I just wanted to be factually correct. That's why I like to do facts. I don't do the guessing games around here. Okay, lady, you gonna be with me or you ain't gonna be with me? You better get on your high heels and go. I ain't with it. I'm with the facts, lady. I ain't guessing games over here with me. See what I'm saying? So look, Bill Worski is the first assistant district attorney for Collin County, Texas. You don't say. Oh, boy. And he serves as the lead prosecutor. Oh, boy. In the Karmelo Anthony M trial, and he presented the state's case to the jury, handled witness examinations, and delivered the prosecution's argument, and later defended the verdict publicly after the trial. I ain't gonna do the Stevie routine yet. We're gonna save Stevie. My glasses is here. Anytime I do this, you already know. Stevie can hear it. He got supersonic hearing. But Stevie can also see the railroad. Oh, boy. Mr. Worski outlined the proposed agreement as follows: that both sides wouldn't go into without character reputation, extraneous evidence for either the Metcalf twins or Karmelo Anthony, and just tried the case based on what happened under the tent. And during another description, during that meeting, what happened on the day of the incident, that benefits the prosecution and not the defense, bro. We need to go into what happened way before that. We need to see why he really had that weapon. All of these things matter before the day, but you only talking about what happens on the day, bro. You get what I'm saying to you? Shit. Seeking clarification, I asked, and Mr. Worski confirmed that this would mean that the defense would not go into evidence related to the Metcalf twin character. I'm gonna try to stop. I'm gonna try to just hold it together, bro. Yo, who with me, bro? Who with me for the railroad? Oh, mommy. Yo, bro. You can't go into their behavior. How the hell you supposed to prove your self-defense until you go into their behavior and their character, bro? Cheerleader scared of them bugging. Please don't tell him it's me because I'm scared what they're gonna do to me. He said my hands is bisexual. Either boys and girls could get them. Even his own mama was scared of him, allegedly. And his pappy. I'm that damn dead pappy. And his pappy was scared of them boys. Don't do this. Don't let me bring up the documentations, bro. You know I'm with them facts. Lord Christ. Look, they would not go into evidence relating to the Metcalf twins' character, reputation, or extraneous offenses, acts related to violence and bullying, inclusive of discipline and write-ups in the Metcalf twins school records within this framework, as well as racism. Oh, boy. In exchange, the prosecution would not go into the character, reputation, and extraneous offenses, acts, and evidence related to Karmelo Anthony, inclusive. Let's go. Karmelo wasn't doing none of that, what they was doing. Let's go. Let's try that one. Let's go. Try. Crazy, bro. That was a good thing for you to stand up and say, hell no with that, because they're going to lose that. They was bullies. They had the record of doing all of that. Karmelo wasn't like that, bro. He was done from the beginning, bro. This shows you the railroad right now, bro. I've been working on the railroad. Oh, in McKinney, Texas. Jesus Christ. In exchange, the prosecution wouldn't go into the character, reputation, and extraneous offenses, evidence related to Karmelo Anthony, inclusive of the contents of Karmelo Anthony's cell phone and school disciplinary records. Go into the records, man. Go into my phone, bro. Okay. At this meeting, I sought clarification on how this agreement would work practically, specifically how to handle the possibility of opening the door to this evidence from either side. During this meeting, Mr. Worski repeatedly expressed his concern that the defense would kick open its own door by asking questions of witnesses that would delve into issues restricted by the agreement. I asked about specific statements made by witnesses interviewed by police and captured by video on the day of the incident. Wait a minute. Let's go back. I asked about specific statements made by witnesses interviewed by police and captured by video on the day of the incident, where those witnesses discussed the Metcalf twins being passionate, triggered, and not tolerating being disrespected. Yo, bruh. Yo, son. Don't let me do it. Don't make me do it again, boy. He needed King Vaughn for a lawyer. RP King Vaughn, bro. He needed King Vaughn to be his lawyer, bro. King Vaughn wasn't going. He wasn't making no agreements with the ops. King Vaughn should have been his lawyer, bro. Nasty work. Look. Being passionate, triggered, and not tolerated being disrespected, etc. Mr. Worski eventually agreed that questions narrowly tailored to ask about specific, listen to this. Mr. Worski eventually agreed that questions narrowly tailored to ask about specific statements that the witnesses made to police about the incident under the tent on April 2nd, 2025, including statements just described about the mindset and the actions of the parties involved in the incident, would not constitute kicking open your own door and thus would not violate our proposed agreement. During this meeting, we discussed the terms of the agreement, being that testimony from eyewitnesses from under Memorial Tent on April 2nd, 2025, and who were discussing the facts of what happened under the Memorial Tent on April 2nd, 2025 would be permissible, and that neither side would go into character, reputation, or extraneous evidence for either the Metcalf twins or Karmelo Anthony. During this meeting, I also asked about the agreement regarding the possibility of the defense calling experts. The prosecutor only discussed how the agreement would apply to the defense experts during the sentencing phase. So I asked how the possibility of the defense calling experts to testify during the guilt innocence phase would impact the proposed agreement. The prosecutor team replied that they had not considered us calling experts to testify during the guilt innocence phase. Who is with me, bro? Who's with me? Who's with me, bro? Who's with me? Sad, what's your name? Sad Bot. I don't know what's your name. Botita. I don't know what your name is. I don't know. You saying justice was served? This sounds like justice to you? I understand Austin was unalive. R.I.P. to Austin. I would never say he deserved to be out of here. I'm not that kind of guy. So I don't, they kids to me. They're children. Okay. And I think this went tragically wrong. But this sound like justice, or does this sound like a railroad? Sad Botita. If this was your kid, would you be happy that this is going down like this? You wouldn't be. I'm not onto nothing. I'm reading the case in front of you. What the fuck are you talking about? They're onto something, not me. Kick rocks. But anyway, have your own thought. This is not an echo chamber. Have your own opinion. So I'm not going to stop you from having your own opinion, as long as we're respectful. Listen, they stated that if the defense called experts to testify regarding Mr. Anthony's epilepsy or about the fight or flight response, they considered expert testimony like that to violate. They stated that if the defense called expert witnesses to testify in regarding Mr. Anthony's epilepsy or about the fight or flight response, they considered expert testimony like that to violate the agreement and thus the open door to character, reputation, and extraneous offenses act evidences. On May 11th, 2026, Mr. Worski, Dewey Mitchell, and Mr. Shook and I discussed the proposed agreement again by phone. I informed the prosecution that we had an informal agreement on the proposed agreement, but that we needed to have the final conversation with Mr. Anthony and his parents to confirm the final agreement. His family don't know law. They fools. During this phone conversation, Mr. Worski confirmed that the agreement would extend to the sentencing phase of the trial as well. And Mr. Worski said that would mean that in accordance with the agreement, the prosecution would quickly rest its sentencing case in chief without going into any of the allegations listed in the state's notice. Mr. Worski said, however, that he would not allow a false impression to be presented to the jury by a defense witness, and that if such a thing occurred, he would respond by going into character, reputation, and extraneous evidence from the state's notice. What, y'all was scared? Was the defense acting like they was shook? Toby shook? He was shook. Ain't no such things as halfway crooks. After the defense asked about an Anthony family member testifying at sentencing, Mr. Worski agreed that the agreement would cover Mr. Anthony's mother only, testifying to the standard, "I love my son, please show him mercy" type testimony only, but no further. Look at all the limitations on this case, bro. People don't even got room to talk, to say what they want to say, bro. On May 21, 2026, the defense and the prosecution teams met with Judge Roach in his chambers. During that meeting, both sides explained the agreement to the judge, describing it again as both sides agreeing not to go into character, reputation, or extraneous evidence as it applies to both sides during both guilt and innocence and the sentencing phases. As long as no doors are opened or false impressions are given, we agreed that that's the best way to document such an agreement would be for the defense to draft and file a motion in limine applying to character, reputation, and extraneous evidence applicable to all witnesses. So it would cover both the Metcalf twins and Mr. Anthony, but if made public, would not trigger reporting in the media about bad act evidence specific to certain witnesses, thus endangering a fair trial. On May 21st, 2026, I drafted the motion in limine as described above and sent it to Mr. Worski by email. It was hand delivered to the judge on the opening day of trial. The defense's understanding of this agreement: the defense understood that the agreement with the prosecution to cover all witnesses who could be called to testify by either the prosecution or the defense about the incident that occurred between Mr. Anthony and the Metcalf twins and their teammates under the memorial tent on April 2nd, 2025, as every description by Mr. Worski described the agreement to allow for testimony about what happened only under the tent. And Mr. Anthony was obviously a witness to what happened under the tent. By the plain meaning of the language Mr. Worski repeatedly used, the defense always understood the agreement to cover Mr. Anthony's potential testimony, just as it would any eyewitness to the incident under the tent on April the 2nd, 2025. Following the plain meaning of Mr. Worski's words in describing the agreement, the defense understood that the agreement to cover testimonies by eyewitnesses, even the eyewitnesses, such as the memorial students underneath the tent at that time of the incident, Hunter Metcalf, and students outside of the memorial tent who looked over and witnessed the incident, and even Karmelo Anthony himself. This understanding of the agreement was further confirmed by events that occurred after the motion in limine memorializing the agreement. That's things that you don't want to say in front of the jury. That's why your striker make a motion. No, I don't want them to say this or something. I don't want the jury to hear that. That's limine. That's what limine means. Right. So memorializing the agreement as was drafted and tendered to the prosecution on May 29, 2026. After a meeting with Judge Roach, the prosecution and the defense to discuss how the trial security will be handled. The parties discussed the timing of the state's case in chief and when the defense case in chief would start. Mr. Worski informed the court that the defense that he estimated it would take 3 days for the state to present its case in chief, which would have ended sometimes on Saturday, June 6, 2026. In response, I voiced a concern to the judge in front of the prosecution team that some of the witnesses the defense anticipated calling to testify were unavailable on Saturday, June the 6th. So I explained that, like in any case, I would not know until the final moment whether we would call our client for sure. But that if the prosecution rested sometime on Saturday and the judge forced us to call witnesses immediately on Saturday, I may not have enough witnesses available to fill up a full day of testimony for Saturday. I explained that if this happened, it would force me to call my client out of order. The defense plan was to call all our fact witnesses, first to establish certain facts, and then to conclude by calling our client to testify as our last witness. So what happened? Yo, who's with me, bro? Slap that like button, bro. Slap that like button. Share this video, bro. Yo, bro. This is crazy, bro. It's absolutely crazy, bro. Can't even nobody say this is crazy, man. Hold up. My goodness, bro. Jesus Christ. On Friday, June the 5th, 2026, the second day of testimony during the state's case in chief, I checked in with Mr. Worski about how he was proceeding and whether he would end up taking more or less time to present his case in chief than he had initially estimated. Mr. Worski informed me that he was moving more quickly than he had initially estimated. So the prosecution was on track to rest his case in chief in midday Saturday. In this conversation with Mr. Worski, I again brought up the fact that several defense witnesses were unavailable on Saturday, and if the judge proceeded with his plan to force the defense to call witnesses immediately upon prosecution resting in order to have a full day of testimony on Saturday, we might be forced to call our client out of order. This time, I did not preface this statement with the perfunctory. Like in any case, I won't know if I am going to call my client at this time at last minute, but I was not on the record and I was speaking frankly with opposing counsel. I was very plain about the defense's intention to call Mr. Anthony to testify and how the judge's proposed schedule requirements were going to force us to call Mr. Anthony out of order. I don't independently recall what time on Friday, June the 5th, that this conversation with Mr. Worski occurred, but it must have occurred just before noon, because I then sent an email to Michael Mauler describing the problem that we were facing and asking Mr. Mola to draft a brief for us to argue to the judge that he couldn't force us to call our client out of order. Throughout the morning and the early afternoon of Saturday, June 6th, Mr. Shook and I repeatedly checked in with Mr. Worski to get updated estimates of when he might rest his case in chief, each time referring to how the judge's plan was going to force us to call our client out of order. Besides the team repeatedly mentioning in front of Mr. Worski and the rest of the prosecution team that we intended to call our client to testify, even if it meant it would be out of order, Mr. Worski's own actions and arguments made it clear that he knew full well that we intended to call Mr. Anthony to testify, even before both sides tendered their notices of the arguments in favor of the admissibility of character, reputation, and extraneous evidence pertaining to the other side's witnesses. Mr. Worski made references to understand that the defense sought to introduce character and reputation evidence about Austin and Hunter Metcalf that was uncommunicated, unknown to Mr. Anthony via the ambiguous aggressor rule, which I just read to you from Torres versus the state. That's the case that it happened. Now, the ambiguous aggressor rule and the admissibility of uncommunicated character and reputation evidence of the decedent in a case are all part of a self-defense argument. Let's read that again. The ambiguous aggressor rule and the admissibility of uncommunicated character and reputation evidence of the decedent in an M case are all part of self-defense arguments. Torres discussed in depth how the ambiguous aggressor rule allows the defense to put on an uncommunicated character and reputation evidence before and after the defendant testifies. So the Mr. Worski repeatedly brought up Torres in discussions with the defense team in months leading up to the trial, stating that while he thought the judge would rule correctly and not allow the evidence, he conceded that the character evidence could be allowed. And this repeated discussion of Torres and how it may apply to the trial showed that Mr. Worski was well aware of the least of the possibilities of Mr. Anthony testifying in order to argue his own self-defense. This was the entire entire purpose of the agreement, and that it provided value to the prosecution, limiting the defense from presenting damaging character and reputation evidence against Austin and Hunter Metcalf. This is what I've been saying the whole time, bro. It aided the prosecution. The defense is fools for this, bro. They fell for the trap, son. And the defense from the defense's perspective, the entire agreement centered around the defendant testifying without impeachment of character, reputation, or extraneous evidence, in exchange for the defense not seeking to introduce character, reputation, or extraneous evidence against the Metcalf twins. Furthermore, any competent criminal trial lawyer knows that for self-defense argument to have any chance of succeeding, the defendant must testify. Like all the other cases in Collin County that I was looking up, even the one white woman that unalived the black guy, her husband, clapped him in the damn house, left him to perish right there on the bathroom floor. Then she blamed it on her two children. The kids was 2 and 6 years old. She said they the one that did it. Pulled the Igga, pulled that. Are you crazy? Left the kids in the house with the dead body. Okay, drove somewhere else. The police and responders came to the house, found the kids in the house with the body. They father. Look at the case. DeRay Sims, Deray Sims, Sims, Morgan Sims. She was the person. Guess how much time Morgan Sims got? After the prosecution was trying to get 25 years out of her. Guess what she got? She got 10 years probation. You wonder? Cool. Stevie ain't got to wonder. But do you wonder? What's your name again in my chat? Sad Botitiria. Who are you? What color are you? That's what I want to know. That's what I want to know, bro. Are you black? Then tell me. I doubt it. Doubt it. So, anyway. Again, furthermore, any competent criminal trial lawyer knows that for self-defense argument to have any chance of succeeding, the defendant must testify. For all these reasons, the defense always understood that the agreement to include Mr. Anthony's testimony free of impeachment by character, reputation, or extraneous offense or bad act evidence, just like every other witness, either side could call to testify about what happened under the tent that day. The defense's reliance on agreement. Throughout the trial, the defense revised its trial strategies in reliance upon the agreement. Absent to the agreement, the defense intended to cross-examine each memorial student witness that the prosecution called about Alston and Hunter Metcalf's character and reputation for violence, for being bullies, and for racism. The defense also intended to cross-examine these witnesses about various statements that they had made to the police on April 2nd, 2025, regarding Alston and Hunter being easily triggered, having a loud mouth, being passionate, and not allowing themselves to be disrespected. Some specific examples include, listen to this, Alston's a really big guy, and he's kind of like the aggressive guy on the team. Alston got the same way that he got during the altercation. Alston got the same way that he got during the altercation is the same way that he got with some of us. And the mellow kid, something or whatever, and then Alston just kind of got triggered. Alston and Hunter, they're not going to let you disrespect them. And Alston, he's like a big guy, so nobody really wants to fight him. And Alston's really a passionate guy. And Jose told the police about Alston's history of fighting and almost getting kicked off the football team for fighting. I've known Alston for a while, and if Alston is about to get into a fight, you can tell. Alston can be a bit aggressive at times, and he has a bolder mouth sometimes. If the prosecution did not call any of these witnesses, the defense was ready to call them during the defense's case in chief and question them as hostile witnesses. Furthermore, the defense intended to call witnesses familiar with Alston and Hunter Metcalf's reputation for violence and bullying. And the defense intended to call witnesses who themselves were victims of the Metcalf twins, the violence and the bullying. The defense intended to question Memorial High School teachers about the Metcalf twins' disciplinary history contained in their school records, which corroborated their character for violence and bullying. And finally, the defense intended to elicit testimony about the Metcalf twins' arrest for racist graffiti. It was being racist to fucking Karmelo, bro. And he knew about their reputation too, bro. You never know about other schools from other kids from other schools that's bully or act like they this and this and that. You knew about other kids from other schools. Even if you went to a certain school, you heard about certain kids. You playing on teams, you probably seen them do things. Other people that got bullied by them, you done heard people's stories about them. You think only a person in your school you're going to know about when you're kids, when you're going to school? Think about when you were in school. Think about it. In good faith reliance upon the agreement, the defense did none of this. The defense even limited its questioning of witnesses about statements that they had made about the Metcalf twins being triggered, having loud mouths and being passionate, etc., that had been deemed to be allowed under the agreement in abundance of caution to avoid opening the door. Furthermore, because the prosecution had made it very clear that the defense calling any psychology-related expert would open that door to character, reputation, or extraneous evidence pertaining to Karmelo, the defense chose not to designate any experts and ultimately chose not to call as a witness a neuropsychologist to discuss how Mr. Anthony's epilepsy impacted his perception of the threat and the response. As that is relevant to self-defense as well, and a forensic psychologist to discuss both brain development of a 17-year-old as well as the fight or flight response as it applied to Mr. Anthony's character. As a result of this revision in the defense's strategy, the defense did not go into these subjects during voir dire or opening statements. That's why, man. Without such an agreement, or if the defense had suspected that the state would violate the agreement, the defense would have explored these subjects during voir dire and would have introduced these topics during its opening statements. In sentencing, in reliance upon the agreement, the defense did not designate an expert who was ready to testify regarding the mitigation, i.e., a risk assessment and psychological profile of Mr. Anthony. Furthermore, in reliance upon the agreement, the defense severely limited its available character witnesses to just 3 questions of Mr. Anthony's mother, which had been previously agreed upon by the prosecution. Other than general character testimony and pleas for mercies, in reliance upon the agreement, the defense also did not go into substantial family violence Mr. Anthony had witnessed and been a victim of in his home. Notification of breach of the agreement. On Saturday, June 6, 2026, the prosecution rested its case in chief and the defense called the witness Adam Linwood, Jeremiah Smith, and Jose Andre Ramos Moro, and before ending the day in the late afternoon, early evening. Now, on Monday, June 8, 2026, the defense resumed its case in chief, calling Brendan Steffens, called Brennan Lacey. The defense next planned witnesses, had been avoiding the defense subpoena and kept changing the time he told us that he would arrive at the courthouse. Who is you, sucker MC? Sucker? Accordingly, after Mr. Lacey's testimony, we took a break at 10:50 a.m. to see if sucker MC, who's blank right here, had arrived. Damn sucker. He was a buster. Straight buster. During the 10:50 a.m. break in the back hallway outside of the judge's chambers, the judge asked us for an update about timing, how many more witnesses, etc. I explained that the next witness the defense had planned to call was a Centennial High School coach. Mr. Worski asked what the coach would testify to that did not pertain to Mr. Anthony's character. I explained that this coach had witnessed Mr. Anthony's seizures, so he would testify about Mr. Anthony's epilepsy based on his own personal knowledge. And Mr. Worski then argued that that testimony about epilepsy was irrelevant at guilt innocence, and to the extent it was relevant, would open the door to character, reputation, extraneous evidence, and against Mr. Anthony. In plain terms, it would breach the agreement. I stated that I disagreed, explaining how it was relevant to Mr. Anthony's state of mind pertaining to self-defense, right? And that it did not relate. Yo, Shadow, where you at, Shadow? It's crazy, Shadow. And that it did not relate to the character, reputation, or extraneous evidence in any way. But Judge Rose agreed with Mr. Worski that he thought the testimony about epilepsy was not relevant during the guilt-innocent phase. These guys are friends. These guys are friends. How many of us have them? Friends. Ones you can depend on. Friends. And that it would open the door to character, reputation, and extraneous evidence based on this. I informed the court that I would not call the coach and that I anticipated having 1 or 2 more witnesses before I would call Mr. Anthony. In response to the judge's question about likelihood of Mr. Anthony testifying, I told the judge that we would need to confer with Mr. Anthony about his Fifth Amendment decision regarding testifying, but I was 99% sure that he would in fact testify. After the break, back in the court before the jury to give sucker MC more time to arrive at court. We then called Frisco Police Department Detective Riley to testify. After the Detective Riley finished testifying, I then decided not to call sucker MC as a witness. And we broke for lunch early around 11:17 a.m. And the prosecution and the defense team stayed behind to talk to the judge outside of the jury's presence. On the way back to chambers, Mr. Worski mentioned to Mr. Toby Shook that from his perspective, I had already opened the door to character, reputation, and extraneous evidence pertaining to Mr. Anthony by saying that Mr. Anthony was a member of the chess club. What? During my opening statement, I did not say anything about a chess club at any time. During my opening, I said that Mr. Anthony played chess during my background description of him and his hobbies. Mr. Worski also stated that from his perspective, the agreement did not cover a testifying defendant. Here it goes. Here it goes. My Sherry more. Stevie Wonder could see the railroad more and more. I've been working on the railroad on the McKinney, Texas. From his perspective, the agreement did not cover a testifying defendant. Mr. Shook alerted me, and Mr. Worski and Mr. Mitchell and Mr. Shook and I stood in the well of the courtroom, and Mr. Worski repeated these statements, adding that the prosecution never thought that the defense would call Mr. Anthony. Why would you not think that? Did y'all just want to railroad him? You need to testify for yourself. Who else going to say that you defended yourself but you? You think people are going to speak about you? When you think in self-defense, you need to go speak to your mindset. To testify, back in the judge's chambers, Mr. Worski repeated his assertion that the agreement between the prosecution and the defense never contemplated the testifying defendant. He elaborated, stating that he had never thought that we were calling Mr. Anthony as a witness, and he also repeated his claim that I had already violated the agreement during my opening statement by saying that Mr. Anthony was a member of the chess club. It is important to note that this was the first time that Mr. Worski mentioned that he believed that I had violated the agreement days earlier by mentioning that Mr. Anthony played chess during my opening statement. Although the prosecution and defense teams had conferred many times throughout the prosecution's case in chief about various issues, and this was the first time that Mr. Worski brought up this assertion. Judge Roach told us both the prosecution and the defense teams that my mentioning chess during the opening statement definitely did not open the door to character. So what the hell was Mr. Worski talking about? He's an op. Why are you making agreements with this man? Even the judge said, yo, bro, what you doing? That's too much, bro. That don't bring up nothing. But look how he digging. He playing psychological games. He's trying to get him not to say certain things and call certain witnesses and do certain things. Mr. Worski won this case, bro. The prosecution, bro. Tricked them, bro. You ever seen the Roadrunner? Yeah, bro. Coyote? Yeah, the defense was the Coyote, bro. He was the Roadrunner. He wins every episode. Yeah, it's a fact. It did not open the door to character, reputation, and extraneous evidence applicable to Mr. Anthony. The parties argued about whether the agreement between the parties covered Mr. Anthony's testifying. The prosecution repeated their position that it did not, and that if we called Mr. Anthony to testify, character, reputation, and extraneous evidence pertaining to Mr. Anthony were in play. Furthermore, Mr. Worski stated at the time that the prosecution, already having rested, character, reputation, and extraneous evidence pertaining to Austin and Hunter Metcalf was not relevant. The prosecution already have rested. Character, reputation, and extraneous evidence pertaining to Austin and Hunter Metcalf was not relevant. When Mr. Shook and I mentioned the ambiguous aggressor rule from Torres, Mr. Worski argued that Torres did not apply because it was not ambiguous who the first aggressor was. Why not? The first aggressor was clearly Austin Metcalf. At this point, The discussion devolved into a shouting match. That's what they was doing, son. Prosecution did what they were supposed to do, bro. Even if we think it's foul, they did what they supposed to do, bro. Why the defense wasn't doing what they supposed to do? That's my question. Answer it in the chat if you want to. Answer it when you see this video on replay. The impact on the defense's case. After the breakdown of the agreement, the defense and the prosecution teams agreed to take 10 minutes off to cool off before attempting to renegotiate parameters for how the agreement could extend to Mr. Anthony's testimony. Should the defense now choose to call him after the 10-minute cooling off period, Mr. Worski and I met in open court outside of the presence of the jury and without the public in the room to discuss the possible parameters for the agreement covering Mr. Anthony's testimony. Given Mr. Worski's expansive view of what he considered would be the open door to character, reputation, and extraneous evidence pertaining to Mr. Anthony, especially his repeated claim after the judge stated otherwise, that it wasn't opening the door, that even my mention of playing chess opened the door to character, I resolved that my only choice was to go over my planned outline of Mr. Anthony's direct examination line by line. Why are you going over this line by line? You're supposed to be able to pull something out, so they need to prepare and get their mind right so they could combat it. We're playing chess here, live. This is a match, a back and forth, a tug of war is a court case, bro. They privy to all of this, so they already know how to prepare for you. Line by line with Mr. Worski to determine what would and not be in Mr. Worski's view the open door. This is how he got him to explain all the little secrets that he thought he wanted to try to help his case, to help his client in the case, bro. Do this full Mike Howard understand this? Who is Toby Shook? Is he friends with these guys? I've never taken such a drastic step of previewing my strategy and even my questions with a prosecutor. Listen to what he just said. I have never taken such steps, drastic steps, of previewing my strategy and even my questions with the prosecutor. It's a tug of war. You're about to prepare for what you're about to say. How are you supposed to win, sir? I'm not a lawyer and I know this. Yo, I stopped smoking trees, man. I might have to smoke a bleezy after this one, bro. It's facts of life. I'm going to get me a split. Truthfully, kids, don't do it. But I think I'm gonna take me a pull of some Bob Marley today. It's over. Listen. But as a defense team, we agreed that we had no other option if we wanted to try to reach an agreed understanding with Mr. Worski of how the renegotiated argument would cover Mr. Anthony's testimony. As I went through my outline with Mr. Worski, what line by line, giving up your whole defense strategy, standing reading the outline over my shoulder, Mr. Worski declared various subjects that in his view would open the door to character, reputation, and extraneous evidence pertaining to Mr. Anthony during this discussion. Mr. Worski repeated his claim that my earlier mention of chess opened the door. While I disagreed with all of Mr. Worski's assertions of subjects that would open the door, I agreed to cut them from my questioning in the hopes of salvaging the agreement to keep Mr. Anthony's extraneous offenses out if he testified. What are those offenses? Let us know. What did he do? He got something that he wants to hide from Karmelo's background. So is Karmelo Anthony's background as clean as we think it is? Why is he trying to hold on to this agreement to hide that? You have to think of both sides, not just the twins. I'm thinking of Karmelo too. Why is his defense team doing this? What did he do? What did he do in his past? At the end of this discussion, with the understanding that Mr. Worski would extend me leeway to lead Mr. Anthony more than normal, though nor the normal through certain aspects of the testimony. In abundance of caution to avoid opening the door, Mr. Worski and I informed Judge Roach that we had come to an agreement as to how the renegotiated agreement would cover Mr. Anthony's testimony. We then summarized the process, and we had just gone through our renegotiated agreement on a record. Now, prior to breaking to allow the defense to retire to the defense room to discuss the issue with Mr. Anthony and his parents, Judge Roach informed us that he was aware of no mechanism at his disposal to enforce the agreement between the parties. Furthermore, Judge Roach informed us that he couldn't even enforce the agreement, bro. You could have been broke that agreement. To hell with y'all. I'm doing my own thing. G-Unit. I started my own gang. G-Unit. Doing my own thing. To hell with you. You should have just got the leg up and just broke it. Whatever, man. Bring what you want to bring up. So y'all already rested y'all case. Break the agreement. See what I'm saying? Judge can't even enforce it. That's how you pull the rug back from under somebody that pulled the rug from under you. Break it. Hell with you. Judge can't inform it. I mean, can't stamp it. Furthermore, Judge Roach informed us that he saw no way for Mr. Anthony to testify without the door being opened. For example, if he said that he bought the knife by accident or said that he was scared, etc., this would almost certainly open the door. Look how they trapped him. To character, reputation, and extraneous evidence of some sort. To clarify the issue, I propose the hypothetical scenario that if Mr. Worski claimed that the agreement had been breached in some way, and if I and even the judge felt that Mr. Worski was operating in bad faith, that the judge was stating that he could not enforce the agreement, would have to make the ruling based on the Texas rules of evidence alone, and that, in all likelihood, the door would have been opened. Judge Roach confirmed that this was the case. When we then broke to discuss the issue with our client, Judge Roach gave us approximately 10 minutes to explain all of this to a 19-year-old kid who don't know nothing about law, who don't know nothing about the situation that he's really in. All he knows is what happened under that tent. 10 minutes to explain the breakdown of the agreement and the proposed resolution with our client before the judge brought Mr. Anthony in for on the record admonishment. Bro, he didn't even know about this agreement. They breaking down this agreement now to him in 10 minutes. Did you really break this down to the parents and say, this is what this agreement's going to be about? Did they go get other attorney, go get other help, use ChatGPT, AI to ask, would this help you? Write down the whole agreement. Let me read it to ChatGPT. My son is in here for an M charge. This is the agreement that they're making. Is this going to benefit the defense or is this going to benefit the prosecution? ChatGPT tell you right now, to hell's no. That's all. There's 3 words. To hell's no. That's what ChatGPT gonna tell you. Not no big paragraph. To hell's no. Shit got me tight. This part right here got me tight, bro. Straight up. I told you, somebody told me read 10. Exhibit 10, bro. Most passion I got out this whole reading, bro. Yo, during the initial pre-admonishment meeting with Mr. Anthony and his parents, I did my best to explain everything that just happened with the help of Mr. Shook and Mrs. Gupta. We then returned to the courtroom for the Judge Roach to admonish Mr. Anthony about his Fifth Amendment rights and also to explain that if he testifies, Judge Roach believed that he had no mechanism to enforce the agreement between the parties and would rule on the rules of evidence alone as to whether the door had been opened. Judge Roach gave us 10 minutes to discuss his Fifth Amendment rights with Mr. Anthony and help him ultimately decide whether he would testify or not. Told you, bro. I told y'all this. I just told y'all this in the beginning of this video. I asked for additional time. I told you this too. I asked for additional time to have such a complicated discussion with a 19-year-old in the most stressful situation of his life, but Judge Roach declined to extend our time beyond 10 minutes. Again, we did our best to explain everything, the pros and the cons of testifying versus not testifying, the likelihood of winning on self-defense if he testified versus if he did not, the likelihood of whether we would get instructions in a jury charge on the lesser included charges of manslaughter and criminally negligent homicide if he did. and if he did not testify, and the likelihood of whether we could get instructions in the sentencing jury charge if we got there on sudden passion, if he did and if he did not testify. During this discussion, beyond all above, the most complicating factors of all was whether Mr. Worski would claim that we had opened the door. Look what they're thinking about still. And then bring in Mr. Anthony's extraneous offenses or bad acts. What are these acts? What are these offenses? Character and reputation based on his actions and claims, specifically his repeated assertions, even after the judge had firmly disagreed that I had opened the door by even mentioning chess, as well as a general claim that the agreement had never contemplated Mr. Anthony testifying. Despite the plain meaning of the word Mr. Worski himself repeatedly used to describe the agreement, bro, he's a prosecutor, bro. He knows for you to really prove self-defense, you need to testify in your own defense, bro. You need to testify in your own defense to prove self-defense, bro. He knows this as a prosecutor, bro. How many trials has Mr. Worski served? Man, it's got to be in his 50s or 60s, probably his 50s. How long has the man been a lawyer before he became a prosecutor, bro? He don't know that? They said any lawyer, bro, a lame lawyer knows this. You need to do these things to prove self-defense, bro. I read that to you earlier. Okay, this was amplified by the fact the defense team felt strongly that the risk of Mr. Worski claiming that we opened the door was too high. So this was amplified by the fact that Judge Roach made it clear that that should Mr. Worski claim a breach of the agreement, he felt that he was unable to enforce it, and that in all likelihood, the door would have been open at the end of the 10 minutes. Despite our request for additional time, Judge Roach called us back into the courtroom to announce Mr. Anthony's decisions and proceed with the trial. Ultimately, Mr. Anthony chose not to testify. This 180-degree change in the defense strategy was the direct consequence of the breach of the agreement. The breach of the agreement affected all aspects of the defense's case. By that time, the agreement was breached, and it was too late to change our approach in voir dire and the opening, too late to ask different questions of the prosecution's witnesses, and too risky to recall those witnesses. To ask questions that would risk the prosecution deciding that we had opened the door greatly hampered our strategy during the sentencing, causing us to decide not to call witnesses we otherwise would have called, and severely limiting the questions we asked of the one witness we did in fact call, and the prosecution's breach of the agreement directly and significantly undermined the defense's ability to present a complete case, bro. Signed and sealed, Mr. Mike Howard, bro. Damn. That's crazy, bro. Yo, bro, that's crazy, bro. That's crazy, yo. That's crazy, man. Whether you wanted Carmelo to be in there frying, whatever you want, bro, whatever you think, bro. You know what I'm saying? I ain't a lawyer, bro. I ain't tried this case, bro. I ain't tried this case, bro. But what I just read to you, bro, is a setup, son. And you mean to tell me what Mike Howard is just foolish enough to do this thing? I was saying from the beginning, remember, I read about some of those things in the beginning. I'm like, they came to agreements. I'm like, what? We only going to talk about everything under the tent. That's it. What? Bro, that only benefits the prosecution. That benefits the state. That doesn't benefit the defendant, bro. I knew this from the beginning. I've been telling you on my last video, I said this. I didn't even get to Exhibit 10. That's crazy, bro. You mean to tell me he didn't plan and the agreement didn't entail his own defendant testifying? What the hell are you talking about? What kind of cases was he trying in his life? I'm going to go through Mr. Worski's whole life and every case he ever tried. And if anybody ever claimed self-defense in a case that he had, and if they ever testified, bro. And how many cases? I had 10 cases where a person pledged self-defense out of 100. And all 10 of them testified. So yet he don't think that Karmelo supposed to testify? Bro, this is how I go to breaking shit down, son. I go to cases, bro. I'm not with the fluff. I'm not with the bumping of my gums, bro. See what I'm saying? R.I.P. to Austin Metcalf, but I'm telling you the truth, son. They were seen like bullies. Even their own students, even them witnesses that was in there was saying that. Even the own witnesses was saying that. Besides that cheerleader that was saying things about them too, bro. They got a history of being bullies. And he's so goddamn big. Nobody wants to fight him. He's 6 foot 200 something goddamn pounds. He's running around like goddamn Randy fucking like Rampage in UFC. Yeah, but this is nasty, bro. This is nasty, bro. Salute to everybody that rocked out. What in the world could they have with a 17-year-old boy that was so bad to not risk testifying? That's what happened, bro. That's what happened. It wasn't not risk it. Everything that they wanted to do, they had this fake ass agreement that they agreed to, which they should have never agreed to. Should have just went into it, bro. Bring up his character. Bring up extraneous evidence. Bring it up, bro. Just bring it. Bring it. Because when we go into the twins, it's still going to trump his. When you go into the twins' background, it's still going to trump his background, bro. Who's testifying that Karmelo was bullies and all of that? His own friends, Austin's own friends is testifying. Cheerleaders on his team is testifying that they like that. They're aggressive. They could be rough. They could be all these things. Who's going to say that for Karmelo? Remember, he was from a whole other state. All they know from him is being a good boy, besides maybe the 1 or 2 incidents that he probably went through. Who's going to testify to that? They're going to go into his cell phone records. Maybe he was saying things in his cell phone. You know, you start talking on phones, you texting people. Keep your phone, get a new phone. You keep your phone, don't turn it off. You leave your phone on. You get a whole new phone, prepaid joint that you're using. Get a whole new line. You use that phone. You keep your phone line on. Here, take my phone. I ain't said shit on that. I ain't never said shit. Y'all never gonna see my next phone though. See what I'm saying? Chill, bro. Salute to all of y'all, man. Hopefully y'all drop likes. I know y'all didn't. I know y'all ain't hit the poll like that. I already know y'all didn't, man. You know what I mean? Salute Drip. Salute to you, bro. You know the vibe. I know y'all didn't. You know, I'll be asking y'all for too much, bro. I'll be here begging y'all for nothing. But yeah, they railroaded them, Drip. You know the vibes, Drip. Yeah, they railroaded them, bro. Stevie Wonder on the way out. My cherry amour. Stevie Wonder can see the railroads more and more. I've been working on the railroad in McKinney, Texas. Whole damn railroad, bro. Whole damn railroad. They agreed to that fake ass agreement that didn't benefit nobody but the prosecution, bro. Nobody but the prosecution, Drip. Nasty work. My man, the plug I'm talking to right now in the chat. My man, him, he hollering them with the railroads and Stevie Wonder. Nasty work, Drip. Nasty work, bro. Yeah, bro. I'm gonna read more of this case in a minute, bro. I need a break from reading this shit, bro. This shit just had me hot. This shit is just crazy, bro. You know what I mean? And I've been trying to be balanced on both sides and just kind of, you know what I mean, give up the story the way you're giving it up. Even though I know what I feel about and see certain things in this thing. I already see the railroads. You know what I'm saying? You know what I mean? Stevie could see it. So he got supersonic hearing, but his ass could see it too. It's nasty, bro. It's just nasty work, bro. Straight, bro.